G'day, Nina.
Hi, Andrew. How are you?
The chaos continues, doesn't it?
I know, but it keeps things interesting. Never a boring day.
No, I must say the last couple of weeks have probably produced some of the most challenging work we've ever had come through the door, hasn't it?
Yeah, it's always like unique, interesting work. So it's good.
Yeah, we act across a number of different industry groups, and in the last 3 weeks, in each industry group, we've had something utterly novel occur, which has required us to go back to the book. So it's been hard, but a lot of fun. Let's get on with today though, because there's some pretty interesting stuff, and I think the first case I want to talk about really is I don't know what is the name of that case, the Fair Work Ombudsman and Chat Time.
Yeah.
This is
the bubble tea company.
Yeah, bubble tea company. This is a case where a managing director and two directors were there, and they got some advice around their payroll.
Yeah, so I think they'd received legal advice that their employees across the businesses would be covered under the fast food award, and then the CFO, in presenting the costing models for payment, presented two costing models. One, which would be an extra $850,000 on payroll, which included everything, so allowances.
But it complied with the, importantly, it's award compliant.
Yeah, it was completely award compliant. And the other one, which they said did minimum award entitlements, would have only been $250,000, and the managing director
and paying cash to people as well. So that was part of it. That part of the, I think it was. That's right. It's there. It's in your notes actually. Trainees were going to be paid cash.
Oh yeah, but okay, sorry. I thought you meant like as to get out of it.
Oh no.
Okay. And so it was the managing director's decision to go with costing model B, and it resulted in them underpaying workers of about $160,000.
Yeah.
And so this case is really interesting because it was about the Fair Work Ombudsman saying, well, even though he had limited knowledge, he was still involved and he should be penalised for it.
And that's the really important part of this. This is a punishment of a managing director. And we've seen cases in the past where we've seen managing director and HR managers punished with a level of knowledge. But this is
like direct involvement.
Yeah, direct. Yeah. This is a case that steps further back and says, but you have a constructive knowledge because you made a decision with the knowledge of what the choices were. You mightn't have had your hands on it, but you knew one was award compliant and one probably wasn't.
Yeah, and I want to stress that they went so far in imputing that knowledge. Like they accepted he had no idea what the award was and he'd never read the award, nothing like that. But the fact that it mentioned award in the briefing he got and he could understand that, hey, one had casual rates and one didn't have penalty, that was enough.
Yeah.
So gone are the days where people can say, oh, I just get a very high level of knowledge and briefing, so I can't be penalised. You can see from here the courts are not afraid to read further into that.
And I think for us, the governance warning about that is don't think you can float in the water without getting wet.
No.
Once you know there's an issue, but you must drill down on it and you must ask the question, does this comply with the award? And if the advice you get is wrong from the CFO and says, yeah, it does, and it doesn't, you're fine.
Yeah.
But if you don't drill down, you're going to get caught. And I guess, look, we've got the lights on again. I've got that polished head again today. I want you to know I don't polish my head before I come on here. It's pretty polished anyway. I understand that. So look, really interesting case that Nina chose because I think it's a pivotal case. I think it's a movement away from the direct knowledge cases we've had in the past to one where if you've got enough tacit knowledge to know there could be something wrong, you must inquire. So this is, to me, the must inquire case. You must take it the next step.
Yeah, and I think really important because there are wage theft laws in effect with jail time, and the federal government is looking to introduce them too. So if they're already reading that into these kinds of cases, that's not to say that they won't do that for those kinds of cases.
Yeah, no, I don't think there's any doubt. Let's go on to a safety case, Mansa. Okay, now Mansa is a case, and it's an ordinary case around an abattoir where people work in the blooding room. It's not a nice name, is it? But it's a place where there's a lot of blood, up to 20 centimetres of blood.
Yeah, pretty gross.
And at the end of that, employees go into a room where they wash their boots, they wash off, they cleanse themselves from that. They're able to go downstairs to another room where there's further cleaning. And Mr. Mansa fell down the stairs because he had both hands full, didn't use the handrail. And what he said is, and he failed to clean his boots correctly. And he alleged that it was a breach of safety in a common law claim. and the judge rejected it. Now, I think Nina and I have spoken probably too often, so you're sick of this line about minimum viable product. But this abattoir wasn't a sophisticated place, but it did have a proper cleaning regime. It did have a process. It did supervise and invigilate that process, and it did direct people to do it. And the choices he made about not cleaning his shoes, carrying things down the stairs, even though he had limited English, and English wasn't his first language, the judge found that Menke was wholly responsible.
Yeah.
And I guess.
And negligent.
Yeah, I guess what we've been saying for a long time is don't wait until you have perfection to introduce something. Introduce things that deal with your highest risks straight away. Train people, do the very best you can, because if you do, you're not going to get prosecuted in safety land. And if a common law claim comes in, workers' comp that turns into a common law claim, although it may not be premium sensitive by the time it's commenced running, can I just be really clear about this? This is a case where you could have defended premium by saying there was no negligence. So even if Nina falls over and is not badly injured, she goes off for a couple of days, but there is an assertion of negligence, our premium will hold at a maximum level, even though there is no injury, okay? If negligence is demonstrated, okay? Because of the risk of a common law claim, and it's sort of front-ending insurance. Here's a case where you could have fought very hard for premium reduction on the basis of there was no negligence. So I just want people to understand this isn't just about preventing safety claims. And yes, I understand common law claims in Victoria fall outside of the premium sensitivity period, except for the initial serious injury part of it. But here's one that you could have defended premium on from day one. And can I say that applies across all jurisdictions? There's capacity to show if you've got the minimum viable product, if you've got the directions, you've got the policies, you've got a good argument to reduce premium, prevent the common law claim, and stop any safety prosecution. So it's not a world-changing case. It's not new precedent, but it is
good reminder.
Yeah, good, really illustrative of where we should do. Okay, performance management, Susie Chico and the Insurance Australia Group.
I think everyone's heard about this case. It went viral.
Did it go viral?
Yeah, because I think this is why I told Tom to summarise this, because it went viral and employees started freaking out about employers' right to monitor what they do from home.
Yeah.
But I think when you read the case, it was perfectly reasonable. Like the employees gone out and said, they were monitoring every keystroke, and it was so she went on the news and everything like that.
Oh, yeah. So this is a cyber surveillance case.
Yeah.
It's about someone working from home and the organisation having a method of cyber surveillance to show when someone started work, when they finished work, and what was the volume of work they were doing. And what they found out of 48 days is 47 days she started late. She didn't go any later than her time, and the level of work was incredibly low.
And some days she just didn't even log on.
Yeah.
But they weren't monitoring that the whole time. It was like she was underperforming, and then they put her on a performance improvement plan and then monitored to supplement the performance improvement plan. So it didn't go from 0 to 100.
Yeah.
But even so, I think it's clear, we need to make it clear that if you're working from home, the expectation is you are undertaking work, and as part of your duties, then the employer is allowed to take reasonable steps to make sure you are compliant.
And I think this also comes back to this issue of saying what working from home looks like. If I'm working from home, I'm working during business hours unless somebody tells me I can work non-business hours. Does that make sense? And that's pretty important for ward employees, because working outside of business hours means you have other penalties that may apply.
Overtime as well.
Yeah. So the idea that you can work from home, look after your dog, take your kid to the dentist and your elderly parents, it is a nonsense unless there is a specific agreement that exists with the employer and the employee. And that's really problematic for ward-based employees and enterprise-based employees. So I reckon this is just a great case, because it reminds of all the things that you and I talk about, which is you start work at this date, you work during the day at this time, you take your breaks, unless there is some specific agreement to the difference. And then please check your awards. Please check your enterprise agreements to make sure that the flexibility you're providing doesn't land on payroll as extra costs along the way. So great case.
Yeah.
And I didn't know it was viral, but it is. I can understand why it is. Okay, let's get on to the main topic for the day. Okay.
Yeah, interesting topic.
The topic for today really is when people use work assets like cars, like trucks. What is a workplace for the purpose of safety law and for the purpose of all other law? Now, we're not going to go to a direct case on it. There has been some cases around it because this is much more of a discussion. But the case that we want to talk about is DPP in Tatura, which is that infamous incident where a truck driver killed 4 people when he was under the influence of drugs, and he's under the influence of drugs because he was fatigued. The organisation he worked for understood the level of fatigue within the organisation and of him,
and permitted him
to drive. Yeah. So what happened is the DPP eventually started off with manslaughter charges. Okay, and they withdrew those charges without explanation, and then they proceeded under heavy vehicles legislation for breaches of duty. What the judge said at first instance made a number of assumptions are based that there was no evidence to support an industrial manslaughter claim, but the DPP had said nothing. And the appeal court said, well, they don't have to say anything and you're not allowed to draw those assumptions. I guess what I wanted to say is the difference between a manslaughter charge and industrial manslaughter is slightly different. This is a case where industrial manslaughter, which has a lower threshold, could easily have been brought.
Oh, yeah.
Yeah,
definitely.
And I guess that's so. The case is not entirely on all fours, but when Nina and I talked about it, we said, because we've had this on a number of occasions where an employee is driving a truck or a on the way to work. The question is, was it a workplace? And we felt quite confident. We said, look, both in workers' compensation law and safety law, it may be a work-owned vehicle, but it's not in the course of work. However, for instance, if they were driving from there, if they went home one night and then went to another work site the next site, so in other words, they drove home on a Thursday night and on Friday morning they went to another workplace using the ute, there's an argument because it's driving to a different workplace that it would be for the purpose of work. And under those circumstances, the vehicle would be a workplace. And obviously, if it's driving between jobs, it's obviously a workplace, but most people don't understand it. And yes, road traffic legislation in all states and territories says, look, it falls under that, but the workers' compensation insurer can jump into it. That's not the issue. We're talking about safety law.
I think you do need to say though, journey claims are
ACT in
Queensland. So travelling to and from work, if you get injured in those ACT in Queensland, same territories, then it is compensable.
Yeah.
But for the most part, it's exactly what you said.
Yeah. Okay. So look, the reason I wanted to agitate is this: I think over the last 2 years, Nina and I have probably dealt with half a dozen cases of people using work-owned vehicles for private purposes and also for work. And in all cases, there were accidents, some involving other people, some single-person accidents. And I want to be clear that you need to have a policy that actually defines what is and what is not work, okay? Because if it's incidental to work, in other words, if they use the vehicle because they need to do that for work, then I'm afraid under those circumstances, both under safety law and under workers' compensation, it's a breach. Yeah. And that means things like being aware of someone's fatigue levels, having rules around drugs and alcohol.
Making sure that they take sufficient breaks and, that they're not, like if you're going long distance driving, for example,
And what we've seen repeatedly is that none of those processes sit in place. And up to date, fortunately, the ones have been driving in circumstances which are not incidental to carrying out work duties, but they very easily could have been. And so we've been able to defend each one on the basis that it's not. But when I look at all of our clients, all of whom have people who are provided with work cars, work trucks that they take home, there is a huge risk. So a truck driver who comes and parks at night after coming from the depot, then goes out to start work the next morning on a run, going out to start next work, coming home on the way because it's part of a continuous journey. It's work. It's not just a journey claim in ACT and Queensland. It is compensable under workers' comp and it is a workplace. So can you just think about this? It is a huge issue. We're going to agitate it again in the problem we've got that's coming up. But I want people to be very clear that things like their FBT actually reflects the truth. So in FBT, people using a vehicle will have a percentage which is private, and there'll be a percentage which is for work, and you'll pay FBT on the non-work related stuff. There needs to be a degree of alignment and a better analysis of what's going on, because when WorkSafe come, they'll ask for that document.
Yeah, they will. Or which we've seen.
Yep.
Yeah. And I think like what we really want to make clear is while it is only a workplace if it is connected to work, the easiest way is just to have that clear policy and to have it very clear in your contracts. Like recently, I've had situations where employees have been terminated and they've got a work vehicle, and then it becomes messy in terms of what they're paid out. So just having that documentation in place will protect you under safety, workers' comp.
Well, that's a classic example, isn't it? When someone says, look, you've got a work vehicle, you're on $155,000. So you're close to the high income threshold of 166, and you've got a work vehicle, part of which is for private purpose. Now, the private purpose part can take that amount over the high income threshold and therefore prevent an unfair dismissal claim. Big issue. Okay. Yeah. But more importantly, if it's part of a dedicated money, then it's part of a use a person enjoys. Then it also, when you're paying someone out, is part of the compensation you're paying
and
someone.
People often forget that. They think you just return the vehicle, whereas you actually have to compensate them for the value, the reduced value.
And your contract can get around that if it's properly crafted. Okay, so if you make that as a discretionary benefit that a person receives, which in no way forms any part of any notice or compensation at the termination of employment, you're absolutely safe. But you don't have that in your contract of employment, you're up for a bit more. All right, well, let's go and test what we've just talked about on the problem, okay? I think a shorter problem, because I did it this morning because I'd forgotten about it. Go.
Rocky was a work supervisor for Road Right, a Pty Ltd, RR. His job was to oversee roadworks carried out by RR for and on behalf of Vic Roads and councils throughout Victoria. Rocky had 3 jobs on the go: part of the Ocean Road between Lorne and Apollo Bay, Western Freeway just outside Rockbank, and suburban works around Hobson's Bay Council. Rocky drove from the Western Freeway site on Wednesday, 5th of July, and arrived at the Mantra at Lorne at 6:30 p.m. He was very tired, but had dinner with an engineering company at A La Grec.
No, it's a real restaurant. I go there.
Oh, okay. Like, that's very creative to me. At Aries Inlet that night. Ben from the engineering company picked him and others up to take them to dinner. Rocky drank much more than he thought. The dinner finished late, around 11:30 p.m. The next morning, Rocky woke up feeling a little worse for wear. He jumped in his car and took off for work near Apollo Bay. Just outside Kennett River, a fox darted across in front of him. He swerved and drove over the edge of the road, falling down a 5-metre cliff into the sea below. He survived the crash. How? Was subsequently breathalyzed by police at hospital and showed blood alcohol levels of 0.034, which meant it was likely he was over 0.05 at the time of the crash. He was certainly fatigued, as he had been working 15-hour days, 7 days a week for the last few months. Rocky suffered serious leg injuries requiring surgery. RR had no policies or processes in place to manage driver fatigue or out-of-work conduct. Rocky was driving an RR-owned ute.
All right, well, that sort of puts it squarely in place, doesn't it? So the first question is, did RR breach its safety law, and if so, how? So let's go to what the duties are. So did they do everything reasonably practicable in providing a safe place of work? And was this a place? So first, was it a place of work? Yes, because he was driving to work and through an intermediary station of the Mantra Hotel in Lorne. So definitely workplace. Reasonably practical. Was there a hazard? Yes.
Driving is a high-risk hazard.
Yeah, he was affected by alcohol and he was fatigued. So there's the hazard, the risks are high. What were the controls? Well, the answer is, here's a guy working roadworks, and you would have thought they had an interlock or some method of dealing with, or some method of testing or checking, or making sure they were educated about the risks of alcohol at least, and its period of time which to get out of it. Because everyone knows the roadwork civil engineering business is a big drinking, hard living place. Okay. Fatigue is a massive issue, and they must have been aware of his level of fatigue. And again, no fatigue processes in place.
And when we say aware, you don't have to be aware by someone telling you. Like the fact that you've got their time records, that's enough to impute awareness.
Or even the fact that you know how hard they must be working given the nature of their work. So they're in deep trouble. They're certainly in trouble for breach of primary duty, okay?
Oh, yeah.
The issue is, could fatigue and alcohol when driving a car create a risk of serious injury? Yes, it could. Were they indifferent to it? We just don't have the evidence here as to that, okay? But the absence of policy puts them at risk. I wouldn't say a high risk. Now, if they did have evidence was led that they'd had prior accidents around fatigue or people using alcohol and driving, then I'm afraid the officers and the organisation would be a high risk of reckless endangerment.
What if, on the flip side, they didn't have a policy, but they had like a informal thing where you had to check in with your manager when you arrived at the hotel?
Yeah, well,
right?
policies can be in writing or not in writing. Yeah. So,
but say he checks in with them and they say, look, I don't think you should continue driving. Don't continue. And he does that. So he disobeys their direction and has been negligent. Would that then go down that path, like you said?
Yeah, I think, can I say at that stage, it would be hard to show a breach of primary duty because you've got a minimum viable product.
And you've done everything. Have you done everything reasonably practical?
No, we haven't done everything, but you have identified a hazard. You've determined the level of risk and you've intervened to prevent that risk becoming a reality. So you've got a control that is in place, and it's a low-level control, but it is nonetheless a control, okay? I think they would have difficulty prosecuting. I'm not saying it isn't a breach, I'm just saying they'd have difficulty because the evidence isn't good for them, and WorkSafe don't prosecute unless they can win.
That's true.
Okay, if Rocky made a workers' compensation claim, would he be successful? Now remember, he's probably over 0.05, and let's just say for the purpose of it that he was meant to be driving 0-0.
Mm-hmm.
Okay, so he is a driver under the Road Safety Act, meant to be at 0-0, therefore he qualifies under Section 42, which means if he's over 0-0 and before 1.2, there's a 1/3 reduction in his compensation, between 0.12 and 0.24, 2/3, and between 0.24 and over, not compensable. Okay, but he must be convicted.
Okay.
But he must be convicted.
And so just testing is not enough.
Not enough. Okay, because you can work backwards and show quite clearly he's been tested 4 or 5 hours later, so he's probably around about 0.09 when he was driving. Okay.
Yeah.
The issue here is there's no evidence that he was convicted, so there would be no reduction in his compensation for that purpose.
And it's definitely a workers' comp claim because it's connected to his point that he was driving.
Yeah, for work. So yes, his claim would be accepted, and there'd be no reduction as a result of the alcohol he'd been drinking. And his common law claim, which isn't caught by that reduction, there may be contributory negligence for A, his choice to drive when he was fatigued, and B, the effect of alcohol. So there may be a 20 or 30% reduction on his common law claim.
Could you also press for a reduction in premium because he was negligent?
No, they can't. No, that doesn't touch premium. Negligence is not a part. So as far as the premium goes, you don't reduce the premium by contribution. It's either no negligence or negligence.
Yeah, but if he's negligent by drinking and driving.
But there's a demonstrated negligence by them in failing to
understand. So negligence or no negligence by the employer. Got you. Right.
Okay.
Yep.
So interesting case. Come on, we've got more to go.
If they sought to terminate Rocky's employment for being over 0.05 when driving a work vehicle, would Rocky have a good unfair dismissal claim?
So there you go.
Why would he have a good unfair dismissal claim?
All right, if they sought to terminate Rocky's employment because he's over 0.05.
Yeah, so if he's breached what he's supposed to, I guess you'd go back to like the alcohol and drug policy.
Yeah, so you'd have it. So can I just say at this stage, no alcohol and drug, no method of checking in. So would it be a valid dismissal? Yes, it would be.
Valid reason.
Would it be reasonable? So it goes to reasonableness? No, it wouldn't, because you didn't have any proper directions in place around it. You didn't have any education about the after effects. Now, if he'd been drinking when he got in the car, dead duck. Okay, but this is from the night before. A fatigued person who's not actually going to metabolize alcohol as quickly because he's so fatigued. He's going to have a good unfair dismissal claim. He'd win.
On the basis of harshness, not on the fact that there's not a reasonable. Sorry, not on the fact that there's not a valid reason.
Yeah, so valid reason, but it's not reasonable, and it would be harsh. So there's two bases upon which you do it. How should Don proceed, and what are the risks?
Well, he needs to manage him for his misconduct.
I don't even know who Don is.
It's his manager. Sometimes it happens like that when I'm like, oh, there's too many people in the case.
Okay, well, there's only Don, and Don is his manager. So and I think I wrote this, so I'm going to have to introduce a little bit extra. This is before the incident arose. So what should Don do as a manager to manage people who are on the road who are fatigued?
Oh, right, okay.
Yeah.
Well, he needs to introduce a policy. I thought you meant now, is to manage him now.
No, too late. He's got a broken leg. All he'd do is tell him to use crutches. No, I mean beforehand.
Yeah, but I think you still can manage someone even if they're injured. Like, he just can't terminate him.
No, okay, but my intention was different.
Well, he should introduce an alcohol and drug policy. He should introduce a clear remote work policy, including risk about fatigue as well.
It'd have to educate. So one of the things about drugs and alcohol is this: you've actually got to tell people what are the effects of alcohol and how long it takes to get out of your system. Because there wouldn't be too many Friday nights that I don't go and have a drink with clients, and I'm up very early in the morning going to the gym. But I know the calculation. I know what it is, and I'm quite careful around it. But not many people know that. And so many people would not know they're at risk when they drive in the morning. And that's why the police sit on around Christmas time, you'll notice they're sitting on major arteries out of town at 6 in the morning because people have gone to sleep in their car and think, I'm good now, but in fact, they're still heavily intoxicated. So there's a lot that Don needs to do, but the most important thing is he needs the minimum viable product. He has to have all those things, make sure that this guy, whose name now escapes me, understands what the rules are.
Yeah, they have to be trained in it.
Competent in it, and then he's got to keep checking in on him.
And he has to also enforce it, because if you've got the perfect policy and says, we have zero tolerance for alcohol, yet everyone is engaging it, you're going to be in the exact same position.
Yeah.
And it's going to be win for unfair dismissal claims. So.
All right. So look, we've got some interesting stuff there, and it shows how in workplace law, other bits of legislation come into effect, like the road safety legislation, define something. So we've got to be really clear about what we do accept and what is the nature of the industry we're in as to what is the level of alcohol use that can be had. But please create policies, process and education so that people don't get hurt.
Yeah.
Because had the right thing occurred here, Rocky wouldn't have driven.
Yeah.
That's the truth of it. Rocky wouldn't have driven. But Rocky did drive because Rocky felt he was safe.
You remembered his name now.
I did, yeah. I don't know. I think it's because I looked down here and saw it. I did write it at 8:30 this morning. Now, I'm going to polish my head and shoot off into another room now, but thanks very much. Let's show us some thumbs up because we really enjoyed being here today, and we'll see you later. Bye-bye.
Bye.